Welcome to all. We are indeed privileged to have the advisory committee address us in regard to this very important, progressive and long-awaited issue paper. We congratulate you on the equity and rights-based approach. We also honor you for your activism and writings over many, many long years, and that have for a long time informed the development of family law and influenced our approaches to problematic issues. Your voices have indeed made a difference for us, and we honor you for that. Without further ado, I hand over to Associate Professor Helen Cruz, who's the chairperson of the committee, and whom we hope will clarify certain of the issues. We hope there will be a very interesting debate afterwards.
Right. So I'm not going to keep my camera on for long. I just wanted to show you what I look like, that I'm not a ChatGPT bot. But thank you very much to the Law Society of South Africa and also to Zenobia in particular, and her committee, her Family Law Committee, for inviting us to present this discussion paper. And I would say that the clarification hopefully comes from your members rather than from us. So I've got quite a lot of just admin to get through before we start on the session. So I'm going to close my camera there. And first, I just want to thank Stephanie and Lizette for the admin around the setting up this seminar. And I also want to say that this is part an information session to cater for those that have read through the discussion paper and have burning issues for us, and for those that haven't read through the discussion paper but have an interest in matrimonial property law. And so we're going to spend the first half an hour or so going through 3 issues that we think are quite pressing to practitioners in South Africa. And then we're going to open up for questions. The people that are with me on the panel, as was mentioned, is Wahida Amin, who's going to follow me on a discussion of the default matrimonial property regime. And then Elsha is going to follow her with the unmarried life partnerships and a discussion with the discretion that we are recommending that courts have upon dissolution. I wanted to do a shout out for these that we really would like comments and feedback on the discussion paper. The whole process at the Law Reform Commission is that we are motivated by the practitioners living through this process. And so the submission date is for the end of November, but we do hope that the Law Reform Commission are giving us an extension. But between you, me, and all the members of the Law Society, we will accept submissions after November. The other shout out is to for those that have an interest in particular aspects of the discussion paper. We've got Law Reform Commission virtual online workshops that will be held at the beginning of December. And I'll be asking Maureen, our researcher at the Law Reform Commission, to send dates. We've got the 4th of December for the religious marriages in particular. We've got 6th of December for customary marriages. And then we have a general session on the 7th December. So if you don't get the answers you want or seek, or you want to focus on a particular aspect, then we hope you can join us on the 4th, 6th, or 7th. but Maureen will send out more details about that. Okay, so what I want to then move to is what Elsha and Wahida and I are going to talk about in this first part of the session. And this is related to the rationale behind the paper. And I'm going to go through these quite quickly because I think everybody here is aware of the issues besetting our matrimonial property context. And so we're asking in the issue paper, which was published in 2018 and then extended in 2021, really whether our Matrimonial Property Act is fit for purpose. And at the stage that it was passed, it was very liberal, very pro-thinking, but that was prior to the Constitution. And in thinking about the recommendations, we've had to think about ideal and non-ideal theory. What is the reality in terms of what people are actually doing out there in terms of registration of marriages, for example, customary marriages. Pragmatism about the state of play. We might think about gender equality and the progression of gender equality in the country, but what is realistic? And then also the development of public policy in other areas, particularly related to good faith in contracts, and I'm thinking particularly antenuptial contracts in this context. And then, of course, those involved in family law will know the recent decision in EB and KG. And it really does strike me that the quote in the quota quo in Freleng versus Minister of Home Affairs was repeated in the Constitution Court, and that quote was, only those who go blindfolded through life can deny that gender equality has not yet been achieved in South Africa. Okay, so with that, I want to just go to my next slide. And I'll go through this quite carefully, but we know that there are facially neutral provisions in the Matrimonial Property Act, which in fact affect mostly women negatively. There's a siloed approach to marriage in this country where different dates, race, homeland jurisdiction affects the outcome of your life partnership. There's an increase in cohabitation arrangements, and Elsha's going to be talking to that. And then we're looking at just best practice in other jurisdictions. So, for example, it's become more and more clear that the requirements for disclosure in other jurisdictions is far superior to that which we have in South Africa. So the question is, what do we do about it? Okay. The other thing I wanted to alert Law Society members is simply to note that we are very much focused on this review of the Matrimonial Property Act in terms of the South African Law Reform Commission processes. And therefore, we don't, we're running in parallel, if you like, with the divorce amendment bill that's just currently gone through the National Assembly, that Wahida will talk a little bit about. And there's also currently a Department of Home Affairs project. They've got a draft marriage bill. But we are running an entirely separate process. We are making recommendations in terms of our governing statutes. And, you know, we're hoping that what we recommend finally in the report that we're going to write will reflect the feedback and commentary and the best possible route for development of this Matrimonial Property Act. Okay, so just to give people who haven't gone through the discussion paper a kind of bird's eye view or overview of what we're trying to deal with here. I've highlighted the aspects that we're going to be talking about today, but just to raise topics that are covered in this discussion paper. So we start off with the recommendations regarding default matrimonial property systems, and then look at the situation of the matrimonial property system in foreign marriages, particularly the fact that we can't continue to follow the lex domicili matrimony of the husband, obviously for reasons of gender and sexual orientation. We also then look at the deviation from the default matrimonial property systems and look at sort of the cradle to grave of antenuptial contracts, looking at the way in which they are finalized and the way in which they are then enforced, making quite a lot of recommendations as to whether we should have formal requirements up over and above the notary requirements upon entering the antenuptial contract. And then obviously the enforcement of the antenuptial contract upon dissolution, which then talks to the deviation measures that we talk about in discretion. We also talk about the possibility of universal partnerships within marriages, and then also the ability to change one's matrimonial property system during a marriage. So currently that's only allowed in terms of Section 21 of the Matrimonial Property Act. But the suggestion is there simpler and cheaper ways of doing that while still protecting the rights of the creditors. There are then separate chapters on customary and religious marriages. Wahida will talk a little bit to the religious marriages. And then Elsha will deal with unmarried life partnerships. We then have a chapter on management of assets during marriage, particularly where it's in community of property, and looking at mechanisms, whether we can improve the mechanisms where there is joint management of the estate. And then the final section of the discussion paper deals with what we call technical issues. And these are quite far-reaching in terms of the disclosure rules that we require, and also the ability of people to claim a right to remain in the family home, for example, living annuities, a right to the share of the income from that living annuity, the possibility of a share in the career assets, and then better ways in which to deal with trusts, particularly where there might be an attempt to dissipate assets. So those then are the topics covered. But in discussions with Zenobia and the Family Law Committee, the committee seemed to be very interested in the default matrimonial property regime. So I want to talk particularly to that and talk to quite a radical idea that we suggest a change. And these, the important aspect is there's a variety of options that we put forward in the discussion paper. One of the questions we asked of respondents is it possible to have one single default regime for everyone? And there was a recognition that different arrangements need to be made for different types of marriages, particularly where those marriages are polygynous. So currently we have a situation where the matrimonial property is in community of property. And there's some wonderful respondents who talk about the fact that everybody knows in South Africa that there is a joint community of property if there's no antenuptial contract. And it's always said that this is the best way of achieving substantial equality. But we've had an interesting discussion, some research about different types of regimes, default regimes. And one of the issues that struck us is that the accrual regime, a default accrual regime, would mean that spouses would still share in the growth of the spouse's estate without them being jointly liable for each other's debts. Now, what's important about this is that we've said the deeming of the commencement value of the estate will be zero in a default situation, because then it allows the assets to be captured as growth in the estate. And we think that this change may in fact be a better version of substantive equality, since spouses are no longer jointly liable for debts incurred in the marriage. And this may provide substantial relief to spouses, particularly women who are saddled with crippling debt. So it's quite a radical suggestion, but we are keen to hear from practitioners whether what are the unintended consequences of such recommendation. When we talk about the in-community or the accrual, if there's an antenatal contract, we do look at the option where customary family property is included and we suggest that it be excluded from the accrual calculation. And we've already had some feedback from colleagues as to how this would actually work. The other issue that Wahid is going to talk about is that religious marriage contracts would be considered to include accrual unless it is explicitly excluded. Okay, so the advisory committee then say the preferred option is accrual as the default in all monogamous marriages. So what would be the case in polygamous marriages? And it gets more tricky here, but what we are suggesting is that the Section 7(6) application ideally would be followed by the husband. So if those involved in customary marriages will know that in terms of the Recognition of Customary Marriages Act, if you enter into a further marriage, the husband has to apply to the court, and the court will deal with the previous matrimonial property regime and govern the future matrimonial property regime. What we know from practice is there's very little to at all adherence to this process. And so we need to think about what would be the regime applicable should people not follow that process. And here we suggesting the regime akin to what the Ramahovi court decided, but that there would be a discretion by the court considering the factors that are set out on the slide. So what did the husband know? What did the husband wife know? The respective contributions to the estate, and then also what has happened to the lobolo. And I think it's important here that if you look at our discussion paper, we do look at intentional disregard of Section 7(6) and a kind of punitive approach to that. But obviously it would be very difficult to prove that someone knowingly disregard Section 7(6). So unmarried life partnerships, if we are to recognize their existence and protect them for the purposes of property, we've got two very simple options. And Elsha is going to be talking about that. But those options are either equal rights to the property amassed during the partnership or no rights, and then a court discretion that would be available. So I'm going to then pass to Wahida, who's going to spend a bit of time on the default matrimonial property regime for religious marriages, in particular Muslim marriages, and for her to just give you a brief commentary. There was some concern expressed by the Law Society Family Law Committee on why Hindu marriages were excluded. Well, they haven't been excluded, but we are keen to hear from associations and NGO groups about how we could best manage those. So I'm going to then pass on to Wahida.
Good afternoon, everyone, and thank you also to the Law Society for giving us this opportunity to talk about our thought processes in putting the issue paper and especially the discussion paper together. And as Helen said, I am going to be talking specifically to the part of the discussion paper that speaks to religious marriages. That is also where my particular specialization lies, in religious family laws and especially Muslim family laws. So just to give you sort of a context within which, you know, we were thinking issues through in relation to religious marriages, that foregrounded the proposals that we eventually made in the discussion paper. I mean, obviously, we start with sections 15 and 31 of the South African Constitution. Section 15, as many of us know, protects the individual right to freedom of religion, but also 15.3 enables the legislature to enact legislation to recognize religious and traditional marriages or personal law systems. And then section 31 allows persons to manifest their manifest their religious beliefs in association with others, so through practice, through worship, etc. But of course, both sections 15 and 31 have internal limitations where the legislation can't be enacted in a manner that's not consistent with other provisions of the Constitution, and similarly, anyone acting in association with others manifesting their religious beliefs cannot do so to the extent that it's not consistent with the rest of the Bill of Rights. And Helen has also touched on the issue of substantive equality, that we embrace a notion of substantive equality in South Africa. And in the context of marriage, and not just religious marriages, but marriages broadly, we note that we are dealing with, to a large extent, unequal power relations between spouses, socioeconomic contexts where women end up contributing in non-financial terms to the marriage. And in the context of religious marriages, it becomes more pertinent because, as we know, up until recently, religious marriages were not recognized. With the Women's Legal Centre Trust case, that was then decided, the Constitutional Court has now said that the common law definition of marriage is unconstitutional to the extent that it excludes Muslim marriages. It also found sections 7.3 and 9.1 of the Divorce Act to be unconstitutional and invalid. Section 7.3 because both sections for not including Muslim marriages. And so in terms of that judgment, we know that interim relief has been provided for parties married by Muslim rights, that if they are engaged in any kind of divorce action, religious divorce, they can seek restitution in a secular court, and they can invoke the Divorce Act to do so. If they are married out of community property with no accrual, they can apply to the court for a redistribution order so that the court can take into account contributions that have been made by one party to the other party in either maintaining or increasing the growth of the other party's estate. With the WLC judgment, parties who are contemplating divorce or involved in divorce actions, who are married by Muslim rights, can institute a divorce action through the Divorce Act in secular courts, and they can now also invoke Section 7.3 if they're married out of community property with no accrual, to ask the court to make a redistribution order for an equitable and just distribution between the estates. And if they're married in community property, of course, they can ask for a forfeiture of benefits in terms of Section 9.1 of the Divorce Act. The court also noted that Muslim marriages will be treated as out of community of property if no agreement has been reached between the parties. Now, I'll talk to the Islamic principles regulating the matrimonial property regimes of Muslim marriages in a minute. But before I get there, I want to just very briefly speak to the more recent case of EB and KG, where the Constitutional Court basically found Section 7.3 of the Divorce Act also to be unconstitutional because it excluded people who were married after 1 November 1984, who were married out of community property without accrual, to be brought within the purview of Section 7.3, in other words, to be able to access a redistribution order. And then also those whose marriages ended in death, whether they were married before the 1st of November or after the 1st of November 1984, they are also now, through the judgment, brought into the purview of the Divorce Act. And of course, the legislation will have to now be changed to accommodate the judgment that has been made. Which basically means that all marriages, including Muslim marriages, would be covered by Section 7.3 now of the Divorce Act. We also have the recent Divorce Amendment Bill, which was adopted by Parliament and still needs to come into operation, which also brings Muslim marriages within its ambit. And with the Divorce Amendment Bill, of course, it's basically giving effect to the Women's Legal Centre Trust judgment. Now, out of the Women's Legal Centre Trust judgment, we also have two processes, law reform processes happening. The one initiated by the Department of Home Affairs, who have published a marriage bill, and one by the South African Law Reform Commission that has published a report that incorporates a single marriage statute. So we still have to see where those two processes go and which draft legislation eventually gets enacted. So the process that we are involved with, in fact, also feeds into the judgment of the Women's Legal Centre Trust case, in that the court, in addition to finding Sections 7.3, Section 9, and the common law definition of marriage to be unconstitutional, also made an order that either existing legislation needs to be amended or new legislation needs to be enacted to recognize and regulate the consequences of Muslim marriages. So one of the consequences is matrimonial property law. And so within in our process of reviewing the matrimonial property law in our country, we also then had to pay attention to Muslim marriages and the way in which matrimonial property regimes of Muslim marriages are regulated. But we didn't only apply our minds to Muslim marriages. We've also applied our minds to religious marriages in general. And so there is a misperception. If there is a perception that that our discussion paper only deals with Muslim marriages, and that is a misperception. We are actually also making recommendations in regard to religious marriages in general. Most of the feedback that we got, however, were from members of Muslim communities. And so a lot of the feedback related to Muslim marriages, and we didn't get any feedback about Hindu marriages, and I don't think hardly any about Jewish marriages either. So we really would welcome feedback on all religious marriages that would be affected by our recommendations. Now, we had to also apply our minds to the Islamic law principles governing the regulation of matrimonial property regimes, and of course also to the religious principles governing marriages like Hindu marriages and Jewish marriages. But particularly Islamic law, well, in fact, I mean, with Hindu marriages as well, the estates is with Islamic law and with Hindu marriages, religious marriages in general, the estates of parties are kept separate. And in the context of Muslim marriages, the Muslim marriage is deemed to be a contract. In the absence of a contract, the default position that has been adopted by majority of Muslims is that the estates of the parties are kept separate, but if parties do contribute financially or non-financially to the maintenance and the increase of the other's estate during the course of the marriage, then they should be and they can be compensated for those contributions. We also looked around at other jurisdictions to see how have, and especially jurisdictions with significant Muslim populations, how have they regulated the matrimonial property regimes, especially of Muslim marriages? And we found that several countries allow their courts to consider financial and non-financial contributions to determine a just and equitable division of the matrimonial properties on dissolution of the marriages. And so these countries, for example, include Malaysia, Singapore, Brunei, Indonesia, Morocco, Algeria, Afghanistan, Kazakhstan, Iran, Maldives, Tunisia, Turkey. So if we look at countries like Brunei, Malaysia, Singapore, and Indonesia, they in fact have default joint property regimes, which recognizes the wife's non-financial contributions in the home. In Morocco and Algeria, as well as Tunisia, the spouses can choose a regime where they can share joint ownership of each other's assets. And all of these countries that I've mentioned include adherents of both the Sunni and the Shia traditions. And the Sunni tradition, mainly the Shafi, Hanafi, and Maliki schools of thought are included, which reflect, the demographics of our Muslim communities in South Africa. So we concluded that based on this research that was done, any three of the South African matrimonial property systems, in community of property, out of community property, with or without accrual, would be consistent with Islamic principles governing the just and equitable distribution of matrimonial property. And so, we also looked at the comments that we received on issue paper 41. For monogamous religious marriages, many, we had a split between those who supported in community of property and those who supported, very surprisingly, out of community property with accrual. And very few, in fact, showed support for an out of community property regime with accrual. For polygynous religious marriages, some said there should be no default regime, but many indicated that there should be a default regime. Some said in community of property, others said out of community property with accrual, others with out of community property without accrual, but subject to a judicial discretion to compensate spouses for their contributions to the growth of the other's estate. And some said we should follow the same approach that exists in the Recognition of Customary Marriages Act. So in respect of, so our proposals for religious marriages distinguish between three types of marriages: for monogamous religious marriages, for polygynous religious marriages, and then where a religious marriage and a civil marriage exist at the same time. What do we do? So in respect of monogamous religious marriages, we came up with three options. The first option was where the default regime should be out of community property with accrual unless the marriage contract excludes accrual. In that case, if not stipulated or if there's no contract, we recommend that the net value be deemed to be nil. The second option is out of community property without accrual, of course, unless the marriage contract includes accrual. And the third option, in community of property. In each of these options, we recommend that the judiciary retain a discretion to make a redistribution order to ensure a just and equitable distribution of the estates. Then for polygynous religious marriages, we recommended an approach that's similar to the approach in the Recognition of Customary Marriages Act, that a husband must apply to court to approve a written contract to regulate the future matrimonial property regimes, that the court terminates the existing matrimonial property regime and then makes an equitable distribution of that estate, that subsequent regimes must be deemed to be out of community of property without accrual, but again subject to a judicial discretion to make a redistribution order that is just and equitable. And if the husband does not obtain court approval for the written contract, the court must then be able to redistribute the estates equitably. Also, if one of the wives becomes aware of the subsequent marriage, she should be able to approach a court for an equitable distribution of the marital estate. And then finally, if a civil and a religious marriage exists simultaneously, we have two options. The first is if the marriages were entered into prior to the amendments coming into effect with regard to the Matrimonial Property Act. In other words, prior to whatever recommendations we make or whatever amendments are made to the Matrimonial Property Act. If the marriages were entered into prior to those amendments, then we recommend that the current status quo should apply to them. That the matrimonial property regime of a civil marriage would apply. But if spouses enter into these marriages after the amendments take place, then they should be given the option to be able to decide which matrimonial property regime must apply. And in the absence of the parties making that choice, then the court should be able to apply a regime that renders the most equitable result. So that's essentially what I wanted to say from my side with regard to religious marriages. I apologize that the slides are not coming up, but I certainly will make them available for distribution. Thank you.
Thank you for allowing us this opportunity to speak to you. And due to the wonders of modern technology, it's really nice to see everybody from all around the country. Yeah, I even saw Oudtshoorn and the Northern Cape. Most welcome. So I'm going to specifically look at what we recommend on judicial discretions and unmarried intimate partnerships. So let's start off with judicial discretions. And sorry if I'm telling you stuff that you already know, but this is just background, because we know that in South Africa, there are basically three kind of big statutory ways in which the courts can overcome or make a distribution of property which is different from what the parties decided about when they got married. And the first is the redistribution of assets in terms of Section 7.3. Then the second then is the forfeiture of benefits in terms of Section 9. And then spousal maintenance orders have the same effect, more or less, but we're not going to discuss them in this discussion paper because there's another discussion paper at the Law Reform Commission dealing with it. So just to make clear what the distinction between the two different types, redistribution and forfeiture orders are, I'm sure you know this, that redistribution orders are available in marriages out of community of property without accrual. They are also, as Wahida said, available in Muslim marriages as a result of the Women's Legal Centre Trust case, and they are also available in customary marriages on slightly different terms as a result of the Gumedi judgment. And the factors which allow a court to distribute in terms of Section 7.3 are related to whether the one spouse has made a contribution, whether financial or non-financial contribution to the growth of the other party's estate. These redistribution orders, as you know, would have been available only in certain marriages out of community of property without accrual, but as a result of the KGEB cases in the Constitutional Court, they are now available, should now become available for all marriages. So that's redistribution orders. On the other hand, we have forfeiture orders. They are available in marriages in community of property and marriages subject to the accrual system out of community of property, irrespective of the date on which they were concluded. The factors, if we kind of broadly speaking, the factors that the courts take into account with forfeiture orders are whether there would be substantial injustice if no such forfeiture order is made, but looking specifically on the duration of the marriage and the conduct of the parties leading to the breakdown of the marriage and substantial misconduct. So it's duration and misconduct, which are factors which are considered in those marriages. Problematic aspect of forfeiture orders is that there are only, the courts have interpreted them to be only available against a party who contributed least financially to the marriage, and I would say that this may be constitutional. There's also another problematic tendency with forfeiture orders is that there seems to be a tendency nowadays to argue that the mere fact that one spouse, and that's usually the wife, made a smaller financial contribution in itself is a basis for forfeiture. The courts have not agreed with that, but this seems to be part of the route of where it's going to. So what do we propose? You will see that if you look through the detailed contents that we kind of give various options, but the one that we are most enamored with, the one that we think that we would like to most comments on and that we think would work best, is that there should be a general judicial discretion available in all marriages, irrespective of the matrimonial property regime, and also available in unmarried intimate partnerships. You'll see if when I get to that. And there seems to have been, in the comments on the issue paper, there seems to have been general agreement on the need for a general judicial discretion applicable to all marriages. And that we want to suggest that the overall factor that the court has to take into account, or the overall criterion that it has to satisfy, is that the court must make a redistribution order if, in the circumstances, it is fair between the parties or basis of equity or fairness, and that this should be irrespective of who contributed financially more than the other party. What we really want special comments on are the factors that we have. We've made a list of factors, I think it's around about page 77, of what we think that the courts should take into account. And I'm wondering whether perhaps these factors are too many of them, or whether any of the factors have unforeseen consequences, which we didn't think about. So your comments are most welcome. So basically what we suggested is that we amalgamate the judicial discretions, the two discretions, so the redistribution and forfeiture discretion. And so we take into account factors which would be applicable to forfeiture, together with factors which have been contribution-based factors which have been applicable in redistribution orders, because we think that it makes sense that you can have duration issues, for instance, in marriages out of community of property with accrual and so on. So we've kind of combined the factors for redistribution and forfeiture together in one list, but we have also added some other factors which courts can consider. And one of the parts of the discussion paper, which we don't have time today to discuss, but which you may want to have a look at, is that we have made some recommendations around getting parties to get independent legal advice at the time when they enter into an antenuptial contract. Also, we have also made some recommendations around duties of parties to disclose to one another their financial positions at the time when they conclude the antenuptial contract, if they conclude one, and also at the time of the divorce. So we've also included factors relating to the conclusion of the ANC and factors relating to failure of parties to disclose financial assets as something else that a court can take into account. Another thing that is new here is that any dissipation during the marriage done in particular ways in order to circumvent an equitable distribution at the end of the marriage could also be taken into account. And then another new thing, which we would like your opinion on, is the possibility, it's done in England, that if there are sufficient assets, the possibility of maintaining the family home separate, so that the party who has custody, or not custody nowadays, care of the children, and the children can remain in the family home. So please do have a look at these factors, and please give us your comments. You know, if you draw up something like this, you know what's in your own head, but you can never imagine the unintended consequences of what it is that you're doing. So this is basically the redistribution discretion at divorce that we are foreseeing. We also have recommended a redistribution discretion when parties don't get divorced, but they are in an unmarried life partnership, and that is what I'm going to turn to next. So when lawyers talk about unmarried life partnerships, we tend to focus only on the first group on my list, the people who choose actually not to marry. So often kind of middle-aged or elderly people, often educated people who decide that they don't want to get married. But they may well be a very small and very privileged proportion of the people who are in unmarried partnerships. So we have to cater for this group of people, but we cannot base the whole of the legal solution just on their situation, because there are also other people who are in unmarried legal partnerships who are in a completely different situation and who didn't actually opt for a choice to forego certain protections. So we know that in South Africa, as in other countries in the world, many people have this strange idea, and that if they've been living together for a certain amount of time, they will be in a common law marriage, and they will have similar rights and protections as people have in marriage. Of course, that's inaccurate, but that's often what people believe. We do have also at the moment different situations for same-sex and opposite-sex unmarried partnerships as a result of the history of the litigation. So that's also something that we have to think about. But a big group of people who are of great concern are people who think that they're married, but there's something wrong with their marriage, and as a result of that defect, they find that after many years, in fact, they have not been married. This is particularly the case when we are looking at customary marriages. We've seen many cases where people challenge the validity of customary marriages, with the result that these women usually who think that they have been wives all along find out that they have not been wives. And related to this is the common practice, it seems, where women often don't know about the fact that husbands have multiple coexisting relationships. So sometimes there will be a marriage, sometimes a civil or a religious marriage or a customary marriage, and then together with that, then other married or unmarried relationships. So these are the different groups of unmarried life partnerships, and we have to find a solution which really caters for all of them. The current position is, as we all know, that the starting point is that there is no sharing of assets at the end of the relationship unless the parties can prove that they have entered into a universal partnership, and in which case the courts will divide some of the partnership property. We also, another thing that we have, another legal doctrine that could help us here, is the doctrine of the putative marriage. But that is a bit problematic at the moment. There's some lack of clarity because it's not quite clear if it applies to customary marriages. It should, but it's not clear that it does. And then there's a great big gap there with putative marriages. If there is a bigamous marriage and whether the second spouse can insist on the benefits of a putative marriage or the property benefits of a putative marriage where the first marriage has been in community of property. So we've got conflicting authority on that. So what we have proposed, like for all of the other stuff, we kind of give people a list of possible options. The first option is to do nothing and to leave this area of law to the courts to develop. They have been doing so, we know, especially in relation to duties to maintain, the Buanya case, the recent Constitutional Court case. So the courts have been developing the law here. However, if you leave it up to the courts to develop, the legal uncertainty is a problem, and it's also problematic in the sense that the people with the least resources are least likely to be able to afford to litigate, specifically to litigate to prove that there's a universal partnership between them. So what our preferred option is that we start off with some or other statutory presumption, and there are two presumptions. The first presumption is that it stays as it is, that there is no sharing between them. Alternatively, that there could be a statutory presumption of equal sharing, which the party then who does not want to share must then bring evidence to show that this is not applicable to their relationship. We also have suggested codification of the rules on universal partnership. And the reason for this is that if it is a statutory, if it's contained in statute, then it makes it somewhat easier for parties who can't afford to go to court to rely on this. But combined with the codification of the universal partnership rules, we have also created a judicial discretion. We would really like your comments on this. This is similar to the discretion to redistribute at divorce, but not all the factors are the same. So there are some other factors which are which the courts take into account, with specifically relating then to the particular context of unmarried partnerships. So the duration of the relationships, do they have children together, all the factors that the courts have formulated in the cases dealing with unmarried partnerships. We have also suggested that the doctrine of putative marriages should be codified and clarified, and it should be made clear that it applies to customary marriages as well as all other marriages, because that just makes obvious sense. But then we sit with the problem of multiple concurrent relationships. I'm sure that practitioners would have seen in practice the situation where wife one thinks that she's the only wife, only to discover several years down the line that there's actually a wife 2, 3, 4, and 5, and now we have to unscramble this egg. And it's a particularly difficult thing to do, because you can't have people or relationships don't start off as polygynous. They start off usually as monogamous, and then extra partners get added kind of over time, and then at the end of a relationships, you now have to unscramble this egg, and you have to, in doing so, you must try. We think you should try to protect the rights of all spouses or partners, at the same time as recognizing that earlier or previous or the eldest spouses, the spouses who have been in the relationship for the longest, may have contributed more. The current way in which courts deal with this situation is to try and find, kind of the wife, the correct wife, and to give all legal rights to this particular wife, and then any second or subsequent wives or cohabitants have no legal recourse whatsoever. And we think that this is not really fair. And so what we have suggested is that, similar to what we suggest in the case of polygynous Muslim marriages, that where one of the spouses find out that there is an additional wife or unmarried partnership, that the court can be asked to do an immediate division of the marital estates if the first marriage is in community of property. So if we have a first marriage which is in community of property, and then a second marriage which is obviously not a valid marriage, but where the wives did not know of each other, that the first marriage property regime would be ended as soon as the application is made, and then that the spouse who is partner in multiple marriages, and this is usually the man, that his half of the joint estate from the first marriage should be then divided between subsequent spouses and or cohabitants. I imagine that this will be a little bit contentious, but this is a solution that we thought of. We think that this is a better solution than simply leaving subsequent wives with no legal recourse, whilst leaving the spouse who is the cause of all this chaos by entering into multiple relationships to walk off with no financial consequences. So these are our comments. If you haven't read the discussion paper, the reason possibly is that it's rather large, and so we, as Helen said, we will encourage you to please comment for us, even if you can't comment on everything. If you can just give us some detailed comments, even on one or two issues in the discussion paper, that would be really good. And we really value the detailed input that we can get from people who actually work with this stuff rather than just from the academics. So yeah, that's my bit, and I will now stop sharing.
Thank you, Elsie. So there are many aspects to think about, and again, we do a very sincere request that as many comments as possible go into the Law Commission. It will be very valuable for this a new direction we are moving in. Again, also from a practical experience. There are two questions which I'm going to put. One to Helen regarding lobola. Returning lobola could lead to socioeconomic problems amongst poorer communities. How would this happen? And one to Elsie. Would a partner to a universal partnership be able to claim back any contributions they made during the subsistence of the partnership upon dissolution?
Thanks for the lobola question. I think when I refer to the lobola, it's not contemplated that the court should enforce any giving back of the lobola. It is only in the discretion of the court in deciding on an equitable and fair redistribution whether the lobola has already been returned, because that then might mean that the division would be slightly different. So certainly not any direction from the court to return the lobola. It's, in the context of a dispute around the marriage, often lobola is returned, and on the behest of the families themselves. And if the lobola has been returned, that should factor into the court's discretion. I hope that's clear.
So whether contributions can be claimed back if there is a universal partnership, you don't reclaim contributions in terms of the universal partnership. So what you claim is a share of the assets, the partnership assets generated, and the share that you will get according to the common law, as the courts have articulated it at the moment, is that the the partnership assets will be divided either according to the parties' agreement, if there is an agreement, or if there is no agreement, then contribution is something that is taken into account. So your contribution the courts will then look at, if you look at the cases, they'll say, oh, she contributed so much financially, she contributed so much in non-financial contributions, her contribution is about, say, for instance, 30% of the partnership assets, and so she can get 30% of that. So I don't think that you would reclaim specific contributions, but that contribution can be one of the factors that a court will consider. Also then in terms of the discretion there.
Thank you. What is a bit difficult for me to get my head around at the moment, I'm a full supporter of in cohabitation or life relationships there being a discretion. Is however the division between a universal partnership and the cohabitation agreement, and whether one's going to differentiate there upon various factors, or whether one's going to have a commercial universal partnership relationship separately from the consequences of a cohabitation relationship.
So one of the factors that is considered in the discretion specifically related to unmarried intimate partnerships is whether there was an agreement and the terms of the agreement. So courts can take into account the agreement, but we suggest that the agreement must not be the only thing that determines how assets are distributed. In other words, our idea is that you should not be able, by way of a cohabitation agreement, to completely exclude any sharing, because you cannot do that in marriages by entering into an antenuptial contract. So it makes sense that you should also not be able to do that in unmarried relationships, but that the existence of a cohabitation agreement is one of the factors which a court can consider.
Thank you. And then the other aspect also is the opt-out clauses which are available, whether by way of antenuptial contracts or religious agreements, etc. And it seems to me to be a bit of a perpetuation of the problem that one's trying to escape from, where there is an uneven playing field, uneven power relationships, and that to me is a concern in the current situation.
Yes, we didn't, I can't remember the whole thing, but I don't think we allowed parties to opt out of the protections. And this kind of connects to the other law reform commission paper, the one on the single marriage statute, where the report is still not out. Please do agitate for the publication of the report. It's been done for a while. But where we recommended in that report that parties should not be able to opt out of the protection, but that the protection or the potential for protection should always be there, because otherwise, as you say, Zenobia, you have the situation where you've got the financially or socially weaker party who's just strong-armed by the other party.
Right. I see there's another question here. When does a life relationship be deemed to commence? The date that the parties cohabited together or not? And then another one, in normal circumstances, one normally follows the jurisdiction of the husband. In the case of civil unions, whose jurisdiction does one follow? In the case of same-sex unions, male, female, etc., what would happen? So assuming that the proposal that's been received from the Cape Bar Council is the one that you're recommending in terms of the issue paper, but please speak to it. Thank you.
Okay, so it's still me, I think. So on the date of the cohabitation, we haven't said anything specific about when the cohabitation is, and maybe we should. So please tell us that we should if we kind of, our thinking is woolly. We have, if you look at the discretion for the unmarried intimate partnerships, there's a range of factors, and the length of the cohabitation is one of the factors, as is whether the parties have entered into a contract, so that it doesn't become a cut-off thing. Because, I mean, it's difficult to say, if you've kind of been living together for a year and a day, now suddenly all the rights arise. But if you've been living together for a year minus 2 days, then no rights arise. So we didn't specifically specify a date there. So please go and look at the factors around the discretion. The question on the jurisdiction, I'm assuming that this is private international law, that thing of the lex domicilii matrimony.
Yes, that's right.
That thing. So that's no longer workable for two reasons. It has been the lex domicilii matrimony is that the law of the domicilium of the husband, and it has become entirely unworkable simply because we now have same-sex marriages in which there's either no husband or two husbands. So you need a different option. But we also think that always following the law of the jurisdiction in which the husband is domiciled is quite sexist and should be changed. So what we have opted for, I think it was Fisher or somebody, there were some academics who put together a kind of like a pyramid of how we will choose the applicable legal system, and it goes like by way of elimination. I think firstly the system that the parties have chosen. If they have not chosen one, then I think it was the system where the parties are both domiciled at the same time, if they have a common domicile at the time of the marriage. If there's no common domicile at the time of the marriage, I think it's a common place where they both have citizenship. If there's not that, so there's a whole range of factors there, which I can't remember off the top of my head, but it's a bit more complicated, but more fair and definitely more workable than simply just saying the husbands.
Elsie, the other thing that was discussed, I know, at the committee was that the tier of factors might be difficult from an access to justice situation and a cost perspective, where you may have to go to court to argue the factors. And would it not be perhaps simpler to say that the discretions in South Africa will apply, or the South African matrimonial property systems, as happens in England and in Australia, for example, and where the regime where they got married is just a factor and not the deciding factor as such?
Yeah, that might be a useful thing, but you know what's happening at the moment is that the world is becoming a much smaller place. So South Africans marry Nigerians in a ceremony in Zanzibar. So then it becomes quite complicated. And I mean, if they're savvy, then they would choose one, but often people don't. And it's the vexing problem that where people didn't choose, there has to be some way. But you can't just say the South African law must apply, because what if one party is South African and the other is not South African? So, but if there's a way in which you think it can work, please just send us those comments. It would be most valuable.
How will the impact be retrospectively, for instance, on customary marriages where parties had to sign as in-community of property on a bond, or marriages governed by their husband's domicile where the wife did not have to co-sign on a bond previously?
So I'll just come in there. What we have put separately is the general rule that changes will be prospective in nature. So there won't be a retrospective application unless people can tell us how that could possibly work and still be fair. So that is a separate question we raise in relation to all the recommendations, is if these changes are put in place, we at the moment recommend prospective application, but where would it be in the interests of the parties and fair to have retrospective application?
Thank you. And Ben, I found Shireen Ibrahim's submission. She says what's important to them would be access to information, advice for those who cannot afford it especially, and then important issues to be considered about children and the impact division of estates have on them and children's rights in participating, their views to be heard in matters affecting them, and of course the home and the consideration of who gets the home will come into play here as well.
If I can just pick up on the home issue, the matrimonial home issue. I've in fact got a master's student who's doing research on the English position. And it's interesting at our higher degrees committee that there was absolute horror at the idea that you could defer the sale of the matrimonial home in the interests of the children. And I certainly think this is something that seems common in many other jurisdictions, and we need to look at it seriously. So if those who are interested in children's rights could give us feedback on that matrimonial home section, we would really appreciate that, because we didn't get too much on it in the issue paper.
I know that the discussion at the committee level was whether the house should be treated completely separately in addition to the discretion that had to be applied. There were, I think, a majority feeling that it should be an all-encompassing discretion that had to be applied. Just for interest's sake. The other question that has arisen was one in regard to the trusts, and we're encouraged to see that there are disclosure provisions for trust. We intend commenting in detail on this because it's in practice a problematic issue, particularly as costs can escalate exponentially. What we were wondering was how the Commission envisages in practice having orders made through a court. Would trustees be joined? Would there be orders against trustees? How would the trusts have to be brought before the court? We know that the personal estates in these cases are usually very small, so that it doesn't help giving all of the personal estate in consideration of what's in the trust. Or would specific transactions in the trust be set aside, and so on? It'd be interesting to see what the views are in this regard.
Ulsha, do you want to pick up there?
On the trusts, yeah, we haven't kind of figured out exactly kind of how, and you are the people who deal with the practical stuff, so your advice would be very useful. Should we join the trusts? What we have recommended is that pending the divorce, or when the divorce action is instituted, the spouses should be entitled to certain information specifically around family trusts, and that we also recommended that the courts should, and we've given a list of factors again there, under certain circumstances, specifically be allowed to go behind, pierce the veil of the trust, or to distribute trust property as if it were marital property. Whether that would involve kind of joining the trust, I'm not sure. It's not something actually I've ever thought about. But please raise these issues so that we do think about them.
And then the further questions, I'll do them two by two. Is it contended that the redistribution provisions will apply on the death of a spouse? And if so, how will this be implemented? And interesting in view of the recent Constitutional Court case. And then next, what are the rights of the spouse who is married in terms of a customary marriage while there's an existing civil union where the husband has passed on? Can she benefit even if her marriage is not registered?
So I can talk about the redistribution at death. We have actually not considered this at all, and it is something that we will have to think about. What the mechanism will be, because the KG case has now said that redistribution must also happen at death, or is one of the things that should be done at death. But exactly what the mechanisms would be is not something that we've kind of paid any attention to. So we do have to think about that. And if you have any suggestions, yes, please. The spouse in the customary marriage where the husband is in an existing civil union where the husband has passed on should be in the same position. So the KG decision seems to have said that whether the marriage ends by way of death or divorce shouldn't make a difference to the proprietary consequences of the marriage, and that does make sense to me. But how one kind of like really embodies these rights at death, whether how you get notice to the different spouses, whether they must contact the master, or how one does it, I have no idea.
So if I can just come in there, because I think, we were taken aback by the EB decision. We were so concentrated on the KTE case. But what's interesting about that is obviously it's on succession, not on divorce. But I've interacted with colleagues who've spoken about the discretion of the master when he contemplates a claim in terms of the Maintenance of Surviving Spouses Act, and whether there would be a claim put before the master and he would exercise his discretion. And, you know, obviously your sort of back goes up and says, but surely there should be a sort of judicial order of sorts. So this is something that will have to be contemplated and considered, and how, you know, is it possible for the master to exercise such an enormous discretion, and how would someone challenge that, and then would it go before the court for confirmation? So all of those things are going to have to be considered. And so if people have any bright ideas, please send your comments in.
You. And then there is someone who again is got a question about the domicile issue, and asking whether it's only the husband's domicile that's taken into account. It won't be. What I would urge you to look at is I've posted discussion paper 160, Project 100E. It's review of aspects of matrimonial property law. It is a long paper, but it does set out in the very beginning questions which we are asked to consider and respond to, and also the factors that are taken into account in regard to the marriage regime. Don't know whether, Elsie, you want to comment on the question?
Yes, Teresa, I think we are talking cross purposes here. I think what you're talking about is jurisdiction of a court to hear the divorce matter. And that is indeed, as you say, just one of the parties needs to be domiciled in the area of the court. What we're talking about here, however, is which matrimonial property, so it's a bigger question, which matrimonial property system determines the property consequences of the marriage when, so that's not which court can give the divorce, it's according to which system will the parties' matrimonial property as a whole be divided. So the one is which court has jurisdiction, and that we find that in the Divorce Act, the one that you're talking about. I'm talking about that horrible old thing, the private international law, where we don't have two South Africans marrying one another in Pretoria or something, but we've got one South African marrying, as I said, a Nigerian in Kenya or somewhere. So these are different things.
Thank you. And just to point everyone also in the direction of the section on antenuptial contracts, which will have far-reaching consequences for practitioners, and there's certain time limits within which certain things need to be done. Personally, I'm not that keen on the cooling off period that is suggested, but for the rest, we welcome that there be a certain period, legal advice, for separate legal advice for the parties and so on before the antenuptial contract is concluded. Are there any practitioners in the antenuptial contract area who wish to raise something in that regard?
Zenobia, I'm not a practitioner, but one of the things we wrestled with the independent advice is obviously the fact that it's going to cost people more. And what we have in the code for practitioners is identifying a conflict of interest, the ability of a notary or someone advising to notify that there might be a conflict of interest as to the impartial advice given to both parties. So we don't know of any ideas of clever ideas of access to justice that you know, sort of lateral thinking of how this could work, where we still have independent advice.
Yeah, we're looking at pro bono projects, and you know, it might be one of those aspects that one will have to investigate. We're also very happy about the postnuptial contracts discussion, and we agree the Section 21 procedure is far too expensive. We have many clients who want to amend their regimes but just simply can't afford to do so. So having notice to creditors and a person up just registered at the deeds office is a great idea. Thank you. Oh, there's a raised hand. Let me see. Put your questions in the chat box and then we can deal with it. I see someone has a raised hand. Let me just see.
While you're looking for the raised hand, just on the antenuptial contract thing, what we have come up with two ideas that could help with the costs of the antenuptial contract. Firstly, is we were wondering whether real lawyers don't want to agitate for this to be included in legal aid. So this kind of advice be included in legal aid because the consequences are important. But you'll also see that we didn't recommend that an ANC which was entered into without the separate legal advice would be invalid. We simply added that as a factor in the redistribution discretion. So if a court is asked to redistribute, one of the factors that they can look at is whether the parties have had independent legal advice when they entered into the antenuptial contract.
I see that Teresa has also posted that in practice she also advises the other spouse that they need to consult their own legal advisor to safeguard their rights, and she thinks this should be a condition. We have 1 more minute left. So at this stage, unless there are any other questions posted, I wish to yes, also maybe create a set tariff for the advice on antenuptial contract. That's very difficult because antenuptial contracts these days have become the most difficult documents to do. For example, in Australia, many of the practitioners take out extensive insurance policies to protect them against future claims. And particularly with the cross-border movement of clients, it has become an impossible task because you may have to get input from England, from France, from Australia, from Africa, wherever they relocate. So it's become a multi-jurisdictional exercise to do these antenuptial contracts. And very often it's a negotiation of the divorce before the marriage. So it's very difficult to put specific tariffs on it in view of the explosion of risks and mobility of people. Any other questions? Then let us just wrap up. Thank you so much for spending your time with us today. It's been invaluable, and I'm sure it stimulated thought amongst the practitioners and academics attending. We've also had interest from offshore jurisdictions. We're interested to know where we are going in regard to our matrimonial property regimes. Thank you for your very valuable time. I hope that you will get extensive submissions from this workshop and that the practitioners will also attend the workshops in December. We do want you please to extend the commentary time because we are all busy working with it and putting our various thoughts together. As you can imagine, there are differing opinions between all of us, which we will present to you in a joint figure from the LSSA perspective, or rather the Family Law Committee's perspective, as well as our individual representations. But thank you so much, very much appreciated, and it was a wonderful lunch hour. Thank you.